right, thank you very much also for organizing this conference in a very timely week, I would say, a very timely opportunity it is, because in this week many things have happened. And I can tell you some of this, others do not depend on me, so I cannot tell you much about it. In the Netherlands today, Cameron will deliver an important speech, so we might not be talking about a lot of EU private law in the future, depending on what he says. Other things that happened to me in particular, not only to me, but some others in the room this week are also important, because I started this week by going to Brussels and visiting the SecGen, Secretariat General, to start a new project, a new research project. The project is supposed to contribute to the impact assessment guidelines, to the revision of the impact assessment guidelines from next year onwards, something that has been anticipated also in the Communication Regulatory Fitness, December last year. I was hoping to find a bit more, let's say, openness towards certain things that will be quoted today, behavioral economics, legal analysis, and so on, but the focus of the research project I've been given and the focus that the SecGen has for the months to come is improving the quantification of costs and benefits. So this is something I want to deal with here. Later on in the week, but this we'll talk a bit further on in the presentation, Fabrizio and I have been visiting DG Markt. And DG Markt, someone has told us that we might want to contribute to an impact assessment on future actions on unfair trading practices, B2B practices. And this is a typical occasion when one thinks, well, maybe I should put a little bit of legal expertise, a bit of law and economics, and not necessarily engage in pure quantitative cost-benefit analysis, which, for example, yields a potential GDP impact. And I'm not sure we got that answer, but please maybe, Fabrizio, if you want to say something more on this about the first impression, because I feel a bit guilty about this, because I've brought Fabrizio into this sort of secret environment behind closed doors where you actually have to consult with institutions trying to make them take better decisions, something that I've done now for almost a decade. Actually, a decade of impact assessment this year, because it's 10 years that the European Commission drafts impact assessments. I'm not sure I did a good thing, but I don't know, Fabrizio, if you appreciated the fact that you found yourself in a completely different environment where normally many of the legal arguments that you use on a daily basis were not, are not entirely or immediately received. So I'll begin the topic, basically the topic that is reflected in this main question, whether RIA, in a broader sense of the word, regulatory impact analysis, we call it impact assessment at EU level, can usefully contribute to the making of EU private law. While thinking about this question, my interpretation of private law was less broad than Jan's, but maybe we can discuss this later. And, well, I approached in the most naive way this question. And the first thing that came out is the following: no. Then I thought the presentation would be too short. So I said, okay, no, but. Well, my dream would be to transform this today into a yes, if. But not more than that. I wouldn't be open to accept any full yes. Because we might want to discuss how to make RIA useful for the making of EU private law, but I don't think we are there yet for the reasons that I will try to outline. I'll be very quick on this because I assume that most of you are familiar with this, but what are the main steps that are normally followed in a RIA, in a RIA document? I'll go very quickly through them because in 15 minutes, otherwise I will need to spend like 6 months on this, but I don't think I have, the impression that you are not willing to stay 6 months here listening to me. And normally what happens, you find in these documents an analysis of the status quo, and normally this is aimed at identifying market failures or regulatory failures in some cases, things that do not work compared to objectives that are either identified by the Commission or are related to long-term policy goals that are identified by EU institutions, for example, the Europe 2020 goals. The identification of a need for regulation, meaning we can do better than the current situation. The analysis of alternative policy options, normally from more like a light-handed into the command and control regulation, possibly incrementally. Consultation and collection of information after you have outlined and sketched a little bit what the policy options might look like and what the main pros and cons could be. And through consultation and collection of information, also through external studies, something that I often engage into. Detailed cost-benefit analysis, which hides an efficiency criteria, of course, in most cases. This should lead in principle to the identification of a preferred option. In most cases, now I'm going to talk briefly about the US experience, the one that maximizes net benefits. Some provisions for monitoring and evaluation over time of these options. And then this becomes an input, a technical input to drafting. Now, this has evolved, as already I've seen in the just description of the conference from the United States experience, mostly. I would locate the birth of this in 1978. Jan was mentioning a conference in Chicago. I also want to mention a conference in Chicago, but this is dated in 1978. It's a symposium on efficiency as a legal concern, where some scholars, for example, Dick Posner, actually tries to promote the idea that Calder-Hicks efficiency, so net benefits, quantifying benefits and costs and calculating the difference, should be the prominent, the paramount criterion that state or public authorities should follow in interfering with market and private autonomy. So this would also apply to adjudication in common law, not necessarily only in legislation passed by Congress. Well, actually, Dick Posner lost that battle in the conference, but he preserved, he won something. Well, actually, he lost the war, but he won one specific battle, that Calder-Hicks efficiency could be taken as a key criterion for secondary legislation only. And this was taken on board by Ronald Reagan and his staff, mostly, when he became president of the United States. And he decided that in order to commit to improving the business environment in the United States, perhaps the best way to do this would be to make it mandatory for regulatory agencies to perform a cost-benefit analysis and demonstrate, make the case for regulation on the basis of net benefits. This would be to stop the regulatory inflation rather than to improve the quality of regulation, to add filters so that to sort of increase the burden of proof for regulating for regulatory agencies. But since this is within the government team, only federal agencies are actually subject to these obligations. So since when the Reagan administration has introduced RIA, RIA is chiefly rooted on Calder-Hicks net benefits analysis, and it is mostly, it is exclusively related to secondary legislation. It's not that the Obamacare was subject to RIA, but the technical implementation measures, of course, will be. This also means that efficiency has for a long time been the one and only criterion that has been followed in a RIA. And I think this is important to recall because I think we have made a little bit of a mistake at the EU level. I don't go through all the nudge here is probably something Alberto will deal with. I don't go through all the steps. But I mean, for a long time and still today, despite some slight changes not fully implemented that have been introduced by the Obama administration, efficiency based on monetization of impacts is what the United States are after when they apply RIA. And they don't do this on the homologous of, I don't know, the Services Directive or asylum rights-related legislation or any other form of registration that will be, of legislation that will be discussed, voted upon, and passed by Congress. And they don't do this also for the independent agencies. So this is why a lot of people said, actually, well, the financial crisis is due to the fact that the Securities and Exchange Commission doesn't have an obligation for RIA, so they didn't have to justify the changes in legislation that they have introduced, in regulation that they have introduced. But also Congress doesn't have an obligation for RIA, so all the new legislations that have, like the Bank Holding Company Act and many others that have determined this situation of commingling of interests that have determined the financial crisis, this also was not subject to a RIA. Well, I disagree with this view because in Europe we had a RIA in 2004 that said with Basel II there's going to be no financial crisis anymore in the RIA document. So it means that if you want to do it, you have to do it right, or if you have to do it with due caution. And I don't think at that time RIA was used for this purpose. So I'll skip the way it works in the United States. I want to just reflect very quickly on the US system, and then I want to talk about the EU and why I think it is still unlikely that a RIA can contribute usefully to the making of EU private law. It is a polar star. It is working. It's been endorsed by 9 consecutive administrations. It is limited to secondary legislation, though. We haven't thought about it in most cases when the Mandel-Kern report then led to the introduction of impact assessment in Europe. Since it is based on Calder-Higgs, it basically almost never touches on distributional issues. This becomes an outstanding problem, of course, the more you go in the direction of primary legislation rather than purely technical regulation. It's different. It could be that regulation on whether to put rubber bumpers on cars doesn't have big distributional impacts, but the Surface Directive is likely to have. The RIA documents in the US basically almost never perform a legal analysis because they're supposed to be purely economic, to look at economic efficiency. Nor they make extensive use of behavioral economics or monitoring patterns of compliance and enforcement, which is something I think should and could be done in RIA, but is not done to a large extent in the United States. So it is technical input based on benefit cost analysis. This is why I put this stamp here. I don't think it's useful. It would be useful for private law. It is not designed as being useful for private law. But this then depends on the definition we give, so I'm sure we'll discuss this further in the questions and answers. The EU level, a long debate from 2002, 1st of January 2003, we do have an impact assessment system. This applies to all major new proposals that are included in the Commission's yearly agenda, the legislative and work program, with the exception of green papers. So there will be white papers, communication, non-binding piece of legislation, very high-level cross-cutting pieces of legislation, and also more technical regulation. Since then, it's been revised slightly, but that's why I told you the anecdote from this week. It seems to me that the focus, at least in the mind of the SecGen, is still cost-benefit analysis, despite the fact that there is this taxonomy of impacts. We have like 65 different social impacts, even more environmental impacts, and so on in the guidelines. But the focus is that this should help a quantification of costs and benefits to the extent possible. Over time, more dedicated guidance that would go more in the direction of legal analysis, some of them have been added in the last couple of years, in particular the specific guidance on fundamental rights that has been published on the SecGen's website. But I found out that the SecGen does not consider any of those guidance documents, from administrative burdens to impacts on micro-enterprises to sectoral competitiveness. They don't consider this as being part of the guidelines. They say this is something we did because the DGs, the other DGs have asked us to open up these chapters. But for us, the guidelines are the set of rules that have to be followed. The rest is not that important. Now, today we are in the middle of the discussion on how to bridge the policy cycle, to mean having ex-ante assessments of impacts, monitoring of impacts over time, and then ex-post evaluations. But there's no debate, if not the one that we try to bring in Brussels, and we can, that's my proposal, we should bring even more on how to make impact assessment more sophisticated and more advanced from a legal perspective, but even from an economic perspective. So impact assessment is still somewhere in the policy cycle on an ex-ante basis, but the most important thing is the methodology it uses, and I don't think they are fit for purpose. I'll skip these things, these slides I might use later on. So on fit for purpose, impact assessment guidelines do not foresee any legal analysis, despite the different scope, much broader that impact assessment has in the EU. The only safeguards are the fact, but this is highly debatable, also in my opinion, that there is, over time, there's this new filter that the European Commission uses, that before they select options that should then be compared on the basis of costs and benefits, efficiency, coherence, and effectiveness are considered to be filtering criteria rather than impacts to be analyzed. Staff in charge of impact assessment is often unable to develop a legal analysis, even an economic analysis in some cases, but yeah, quite often it is unable. And having done quite a few of those impact assessments myself, or supported the Commission staff, Commission services, I can say this. Secretary General is focused on cost-benefit analysis, not even on behavioral economics, and not even on, as I was saying before, on guidance on fundamental rights. So I'll go quickly with this because I want to come to the conclusion, but conclusion early in the morning, it can never be real conclusion, more a set of open questions. Whether impact assessment can be said to have improved EU policy making, I think the evidence so far is mixed at best. I think we need many corrections to the system before it can actually be made useful. There have been many difficulties. I think the most important of this, even if we make it very good, and I don't think we're there yet in the European Commission, this document dies immediately the moment the Parliament takes the proposal. So we can make the most sophisticated and legally savvy impact assessment documents. But until the European Parliament and the European Council, following the interinstitutional agreement on better lawmaking, will start following the same methodology in discussing major amendments, this document will always be a piece of history. Could be a better piece of history or a worse piece of history, but I don't think it will be really shaping final decisions and final pieces of legislation. The European Parliament has just started, created a directorate for impact assessment. I've been giving them training last year on impact assessment, and I met all of them. And I think in the medium term, not in the short term, they might be able to develop their own impact assessments. But it's still, we're not there yet. Council, I don't think we actually have any hope on that. There's also still too much emphasis on costs in impact assessments. The standard cost model, compliance costs, all of this is still seems to be more under the spotlight than any assessment of benefits or the specificity of the legal systems that we're trying to harmonize, for example, or the inherent design of the rule, which is something, and the incentives behind this, the incentives that the rule generates, which I think are not there yet. I want to give you just a few examples. I have 5 or 6, but I only focus on one because of time constraints. It is this one. And I'm trying, in the attempt to give you some beacons of hope, because so far I think I've been pretty negative, so I don't want to be too negative. When the European Commission decided that they wanted to launch to adopt a white paper on private antitrust damages actions, they had a bad idea of calling, well, launching a tender. They had a bad idea of selecting a consortium that I had the honor to guide, to lead, that actually had to decide whether there could be changes in the rules, including procedural rules that apply to antitrust cases, to tort cases generally, that could make the exercise of a right that is rooted in the treaty, the rights to damages, connected to antitrust rules that we have in the treaty since 1957, to make it more effective. Principle of effectiveness. So what they told me as a project leader, there were many comparative lawyers, including Roger van den Berg, for example, and that team. What they told me is, we would like to know from you, you can do whatever you want, but what we would like to know from you in this impact study, what would be the impact on GDP of having an ideally more effective private enforcement system? And I asked them, how do you get there? What do you have in mind? What rules do you want to change? We don't care. Then we'll look at this later on. But we want to have the frontier. We want to have the GDP impact. The rest, your hands are free. So I don't think this is the basis on which we perform legal analysis. I don't think this is a good basis for performing an impact assessment. So what I did, I wrote 100 pages of tables where I was actually asking the question, if Europe were like the US in terms of mix between public and private antitrust enforcement, how much billion euros, how many billion euros would be recovered in terms of damages actions? How many cartels might be deterred? And then I started the real question. Another 600 pages of models. Modeling of incentives in law and economics in litigation. Meaning, put yourself in the position of a victim. And what are the costs and benefits from the perspective of the victim in behavioral terms? Going to the judge, suing for damage compensation. And put yourself in the position of a would-be cartelist that has been just invited out for dinner. What would be the costs and benefits of joining a cartel? And that's for all the other conducts, of course. And this doesn't give a figure. It just tells you which rules, which combination of rules are actually more likely to incentivize meritorious lawsuits and not giving false incentives for strategic lawsuits. Which rules are more likely to deter without over-deterring? This is not the current way in which we do impact assessment. This is the way in which we did the white paper on private antitrust enforcement. But this is basically a unique, not necessarily, we tried, but I think this is something that should be consolidated over time with experience and with all the contribution of those that have experience and competence in this field. So what happened at the very end we made a test on the basis of which combinations of options between treble damages, punitive damages, access to evidence rules, passing on, limitation periods, collective actions, a number of things that we had compared in scenarios, which ones would be more difficult to accept and would create more adaptation costs for national legal systems. So which ones would be more feasible in this sense while preserving positive outcomes, not in sense of GDP, but in the sense of giving the right incentives. So for those of you who are interested in developing this type of alternative methodologies, I think this is a good example, although it's an example where I've been involved, but I think it's one of the only so far. Similar things have happened with different results, less evident contributions in other impact assessment I've been involved in, not in the fourth one. I haven't been involved in the Common European Sales Law, but these are all examples on which we can discuss. And that's the new one where Fabrizio and I will definitely do our best to introduce more deep and thorough legal analysis before we actually propose rules that bring us towards some efficiency frontier that nobody actually can identify with precision. So, last slide, just to reassure the chair. Can we actually contribute to private law? Yeah, I'm trying to put this into a yes-if. What we need to build a better RIA system. I think we need a comparative law and economics approach. Something that introduces in our impact assessment guidelines some more competences and ability to assess what the impact on legal systems would be when we harmonize, or even when we want to create a brand new rule completely. Let's focus on Calder-Hicks, recognizing that we have a different system compared to the US, more on incentives modeling and incentives analysis. We might want to go beyond efficiency when we deal with issues that are not necessarily technical regulation. This is, in social sciences, a long-standing problem. Even Amartya Sen has not made it, so nobody else can make it. But so is in I think his last book, The Idea of Justice. He tries to depart from John Rawls' idea, theory of justice, by trying to operationalizing, so finding out criteria that would lead us not only to understand what is an ideally just world, but also to understand how do you judge between two suboptimal states of the world, whether some more in the direction of justice or less. We're not there yet. We need feasibility checks based on comparative law analysis. We need an understanding of legal systems, of legal traditions. We need perhaps the legal service in the Impact Assessment Board to perform these checks, because the current members of the Impact Assessment Board have a passion for impact assessment, which is already a problem for them, of course, because it's not easy to develop a passion for this. But at least they do their job to the best, that they can. But I'm not sure they will be able to shift in that direction. We need a better understanding of compliance and enforcement patterns. I'm sure Alberto will, to some extent, when you talk about regulating behavior, will go back to this. And we need to understand complexity in the way people react to legal rules. From typical law and economics arguments such as rational ignorance or even bounded rationality, into the issue of equilibrating tendencies. When you try to change a rule, a national government that wants to preserve that rule that you are changing has several channels, several avenues to preserve it in place, by under-enforcing the new rule, over-enforcing it, by letting the rule pop up from antitrust law into civil codes. And these things have to be understood. When I did the study on national rules that are stricter than Article 102, use of economic dependency, prohibition of sales below cost, and so on. Several of these conducts were located in completely different parts of the corpus of laws of the countries we were looking at. And many countries that would not have the antitrust law available anymore to regulate certain behaviors, for example, to protect local producers, they have several other ways of doing that. So you need to understand how legal systems react and how people react to legal rules. You need to understand how to use social norms, herd behavior, peer pressure, in order to generate certain behaviors that you want to, you consider as being desirable. And the list is much longer, of course, but I guess I have to close here. So I leave it there. My answer is a yes if, but I think rather than being a conclusion, this would be a call for the beginning of a new way of looking at impact assessment that I would very much like to see as being a practitioner in impact assessment so far, a rather frustrated one, being a law and economics scholar in the remaining part of my life. This is my contribution so far to today's debate. I'm very happy to take questions or, compare my experience with yours in a way that perhaps will help us understanding what the perimeter or a potentially better impact assessment system might look like. Thank you very much.